Okay, thank you very much. So my name is John Taggart. I'll be talking today about maximising the use of registered intermediaries for victims and witnesses. So if you don't know what a registered intermediary is, don't worry, that will become clear very soon. But just one preliminary point to make. Whilst I'm speaking about this role of the intermediary in the context of witnesses and victims, as that's the theme of today's workshop, I do support this role for suspects and defendants as well. And a theme I want to make throughout this, and I don't think this should be controversial at all. In the adversarial system that we have, very often the rights of defendants and victims and witnesses are pitted against each other. I think that's a zero-sum game. We don't need to do that. Participatory rights for all protects the administration of justice. So whilst we're absolutely focusing on witnesses and victims today, there's no need for a contest between those rights or participatory entitlements, in my view. So I'm going to be talking about vulnerability in the criminal process more broadly. To put the intermediary in context, I'll be speaking about what special measures are and how the intermediary fits within that framework. I'll be looking at Northern Ireland as a quite unique jurisdiction in this area, but as we tend to do in this jurisdiction, England and Wales is an interesting and instructive comparator. A snapshot of intermediary provision in Northern Ireland. What's it like on the ground? How is this special measure rolled out, numbers-wise? Current research into intermediaries. Very few people have been doing it. I'm one of the only ones, and certainly in Northern Ireland. And then where do we go from here? This isn't going to be purely descriptive. I want to give you an idea of, 2026, what do the next 10 years look like in this area, for example? So the reality is that anyone who interacts with the criminal justice process is likely to be disproportionately vulnerable. That goes for witnesses, victims, and defendants. Some of the stats are absolutely shocking, particularly for defendants, I have to say. I was looking at research over the weekend that 1 in 2 suspects in custody have an unidentified diagnosis. ADHD is 1 in 2. But witnesses and victims are vulnerable as well, and that's super important to stress. Autistic witnesses, for example, are more likely to experience impairment in temporal cognition. Autistic witnesses are more likely to confabulate, which means to unconsciously fabricate memories to fix gaps. So you can imagine in the context of a AB interview with police, a young autistic witness, not deliberately but unconsciously making up and fabricating bits of evidence to fill in gaps of a story is very difficult evidentially for police to piece together an investigation. Police often fail to detect issues such as learning difficulties, communication issues, mental health issues, mental disorders. That's as true in Northern Ireland as it is in England and Wales and other jurisdictions, a huge challenge for law enforcement. And young witnesses, the archetypal vulnerable witness as a child, are much more suggestible and they have high sensitivity to reward. So we're not even talking about the court process here, just at the initial investigative stage when police are trying through very careful means to understand the evidence of a witness. Children being very suggestible, police have to be very careful to ensure that the evidence that they are eliciting is reliable and coherent and accurate. So the context of my talk today, because I'm going to focus in on one special measure called an intermediary, but the context is special measures more generally. So in 1998, just after the Labour government were elected, the Speaking Up for Justice report was published that contained 78 recommendations which sought to improve the treatment of vulnerable and intimidated witnesses within the criminal justice system and to enable them to give their best evidence. And this is a phrase you'll hear all the time, best evidence. Very few people actually hone in on what it means. Best evidence means the quality of evidence based on its completeness, its coherence, and its accuracy. So all the time we speak about ABE interviews, achieving best evidence. How do we get to best evidence? We're talking about how do we make sure evidentially that evidence is complete, or as complete as it can be, coherent and accurate. Now, there was a panoply of special measures introduced both in England and Wales and in Northern Ireland that range from using screens in court Evidence by LiveLink, which now Northern Ireland is championing with the use of our REC, Remote Evidence Centre, where a child witness does not have to go near a court. They can give evidence remotely, never having to go in to see the inside of a courtroom. Evidence given in private, removal of wigs and gowns, video recorded evidence in chief, video recorded cross-examination, which we're not there yet in Northern Ireland, but maybe watch this space. Aids to communication and an intermediary. Now, just before I focus on the intermediary role, a lot of these adaptations existed prior to this prior to 1998 and the legislation that followed 1 year later. Judges routinely would allow these sorts of accommodations using their inherent powers in court, but that this piece of legislation solidified those in legislation to allow lawyers to make applications based on a coherent piece of legislation. The role that I'm focusing on today is the role of the intermediary. I'm not saying it's the most important. I'm not saying it beats all the others. It's just the one I'm focusing on today for the purposes of my presentation. Sorry for the formatting. What is an intermediary? An intermediary is the only special measure that's a human being. It's a person. A screen or a live link is a piece of machinery or technology. An intermediary is a person. And they're normally speech and language therapists or social workers, but mostly speech and language therapists. And they're neutral, and their role is to facilitate communication between a vulnerable individual, a witness or a victim, and the criminal process. They're normally speech and language therapists, as I said, and they assess a vulnerable individual and recommend practical communication strategies, and they're recruited, trained, and provided by the Ministry of Justice in England and Wales and the Department of Justice here in Northern Ireland. Very practically, in a case, that will look like is there will be an intermediary that is matched with a child. So there will be a request made. The Department of Justice, through its secretariat, will match the child with one of these intermediaries. They will perform a comprehensive communication assessment. They will then provide a report to the police on what this child's communication capabilities are like. Practically, during an ABE interview, what are the best strategies to employ to communicate with that child? Very often that can be very simple strategies, taking your time, 1 point per question, but it can also be about the environment. Don't do this ABE interview in a room with a clock or with the certain colours, because that might trigger the child, etc., etc. So it's very practical, and it's focused on how can that child best communicate in this interview environment. The legislation that we have in Northern Ireland is relatively clear on the role. In practice, maybe not so clear, but on paper, the function of the intermediary is to communicate to the witness, questions put to the witness. So if that's in an ABE interview, questions from the police to the child. And to any person asking such questions, the answers given by the witness in reply. So does the child understand the questions being asked? And are the answers given back to the police officer, for example, also comprehensible? So that's that two-way communication. And the intermediary is not a lawyer. They don't represent the child. They're neutral, but they are there to facilitate that communication between the police and a child. At court, that would be between a lawyer and the witness. England and Wales and Northern Ireland are relatively quite different in this regard. In 2004, intermediaries were rolled out in England and Wales on a pilot basis, only for victims and witnesses, not for defendants. In 2013, when the pilot scheme was rolled out in Northern Ireland, some 9 years later, the role was extended to defendants, suspects, witnesses, and victims. I think this is a very good thing, and this is why I don't think we need to pit witnesses against defendants here. A vulnerable person who needs communication assistance should get it, and it leads to fairer outcomes overall at the end of a trial process. My research to date, and I will speak a bit more about this, shows that our system works very well. Okay, we have a system whereby intermediaries assist victims, witnesses, suspects, and defendants across the board. There's no distinction between the two. What has lamentably happened in England and Wales, thankfully we didn't take this route, is that there is a separation between those who assist communication for witnesses on one hand and defendants on the other. So some people who do this role, not for their fault at all, some people are defendant intermediaries and some people are witness intermediaries. This is a neutral role. That distinction should not exist. If you facilitate communication, you facilitate communication. So our Department of Justice, with the assistance and support of our judiciary, And the Lord Chief Justice, as he was then, Sir Declan Morgan, said that this must exist across the board. So we now have, I would suggest, the world-leading intermediary model in terms of assisting communication of vulnerable witnesses and defendants in the world. Australia is looking closely at our model and looking to replicate it, but we're the first country internationally to implement a rule like this for all vulnerable individuals. I think that's something we should be proud of. Snapshot of intermediary provision. What does this look like on the ground in terms of numbers? Historically, about 70% of all appointments of this role are for complainants or victims of crime. Okay? About 20% of it has been for suspects and defendants. That's pushing up more towards about a third now. But as you can see, year on year, there's been an increase, but roughly those percentages are across that 4 or 5 year period. The age of the service users, as you can see, children, 0 to 7, 26% of all intermediary appointments. The reason for that is that in Northern Ireland, this is a policy decision taken by the Department of Justice. A young witness up to the age of 7 must be appointed an intermediary. It's not mandatory. If there's a child witness up until the age of 7, they must be appointed an intermediary. From 7 to 18, it's discretionary, but children are eligible, but it's not mandatory. But as you can see, we have vulnerable witnesses coming to court, elderly witnesses, sometimes with dementia, Alzheimer's. If their evidence is extremely important in a case and they need assistance, the Department of Justice is actively appointing intermediaries for that kind of witness as well. Okay. This is the intermediary referral by need. These are the figures provided to me by the Department of Justice. You can see the range of vulnerabilities. Young age is, by quite a distance, the biggest vulnerability. As I said, children are the archetypal vulnerable witness. But you can see learning disabilities, mental health, ASD, aphasia. There isn't one type of vulnerability. Now, this highlights the importance of the intermediary role because going back to the start of the process, we do expect the police and healthcare professionals or the police at the early stages with the witness to identify vulnerability. If it's a child, it's easier. But the police have a very important role here to identify, is this witness someone who might need assistance here? And thankfully, the police are doing a really good job at identifying all different types of witnesses who may need this type of assistance. Now, where are we? You might think, well, you said we've got the best model in the world. What more do we need to do? There's absolutely always room for improvement. And whilst we do have the most progressive model, this is such an important role that can be maximised. And why not do it in the jurisdiction that's taken the role most seriously in the first place? So my own research, my own PhD research that looked at intermediaries on the ground in England and Wales and in Northern Ireland, it wasn't a purely comparative piece, but it demonstrated that the system we have, where we have this role for everyone, works better. And it enforces the neutrality of the role. We don't have a distinction in Northern Ireland between defendant intermediaries and witness intermediaries. Police at the police station, lawyers in court are much more used to dealing with the intermediaries as a communication specialist. They don't pertain to the defence. They don't pertain to the prosecution. Sadly, that has not been the case in England and Wales. This idea of the emergence of a role for defendants and witnesses is what they have to deal with. But Northern Ireland, we have a really good starting point here that actually this is a role that has gained legitimacy and trust from criminal justice professionals. And I think we can take that forward, as I'll explain. Just very briefly, I've done some comparative review of criminal barristers in England and Wales and Northern Ireland as well. I can't go into that in much detail here today, but it shows that the trust that our criminal professionals in court have in the role is higher here than it is in England and Wales as well. And I believe that's due to the neutrality that the role has gained, or a legitimacy and neutrality that the role has, which I think is definitely something to be commended. And my own work is looking at the role at the investigative stage, which is ongoing, so I don't have too many concrete findings yet in that. But some of the key takeaways from Northern Ireland before I talk about next steps. We do have one of the most comprehensive schemes internationally. There's significant buy-in from legal professionals, including judges, who speak very highly of the role. There are fewer concerns about impartiality, And let me tell you, countries that are looking at this model now are very concerned about how this role will be accepted and viewed by criminal justice professionals. And they're looking here to say, well, it works well here. Can we replicate it in other places, Australia and New Zealand in particular? It's very well run, efficient scheme overseen by the Department of Justice. I think we do benefit from our size in Northern Ireland. We have 33 intermediaries in the whole jurisdiction. They all work very closely. There's good peer networking. And managing a small cohort of this kind of role is much easier than in a bigger jurisdiction. And it's based on equality of arms. I make that point again for the third or fourth time. This works well because it's for all vulnerable people, not just witnesses, victims, or defendants or suspects. What hasn't been done yet in the research, and absolutely there's scope to do this over the coming years, is to look at the impact intermediaries have on best evidence. We can all agree it's an important role. Young children in particular should have this assistance right from their interview with police through to court. But looking at the empirical qualitative research, what we need more of is how does this role impact the completeness, the coherence, and the accuracy of the evidence, and something which I think needs to be teased out. And if I had another hour here, I'd go into it. But are there situations where the protection of children and ensuring that their journey through the criminal justice process is enabled, but also the best evidence is promoted? Is there ever a tension between those two things? So let me give you a very brief example. In some cases, is it best for a child not to give evidence because it might scar them, it might re-traumatize them? That's a legitimate concern. But securing their evidence in a case is so important to ensure the perpetrator is brought to justice. And ideally, you can ensure both best evidence and the child's best interests, as per the convention, are respected. But if there is a tension there, how do we think about that? Maybe watch this space for research on that. Where can we go from here? Well, I've got 3 minutes, so I'll try to condense this. We do have a world-leading scheme, as I said, and it's internationally unique in its provision. I think there are 3 key areas for development. This idea of mandatory training for all legal professionals, this was suggested about 15 to 20 years ago in England and Wales. There's a report called Raising the Bar, and on paper this was great. All legal professionals, in particular advocates at court, should be trained specifically how to ask questions of children and treat them not as mini adults, but as children who need to be handled differently. That was never implemented. The Criminal Bar Association pushed back strongly. We have a relatively small jurisdiction here whereby something like this could actually happen. I'm not saying there wouldn't be resistance, but we have one training scheme for barristers at the Institute of Professional Legal Studies. Why don't we have this as a mandatory training for all trainee barristers and solicitor advocates as well, right from the start of their training? That is happening ad hoc, but we can do it on a mandatory basis. Why not? It's much more difficult in bigger jurisdictions. I think that would make a real material difference. Requirement for all young witnesses or victims to be appointed an intermediary. At the minute, all children under 7, it's mandatory. And I confess this second point is based mostly on anecdotal evidence, conversations I've had with intermediaries, but they're all strongly in favour of all children up until the age of 18 having a mandatory right to an intermediary for their evidence. One of the practical reasons for that, a few have told me, is children who don't get an intermediary at the early stages very often end up getting one at court anyway. So they've been through their earlier evidence with the police, and then for the court stage they get an intermediary, but they didn't have that assistance at the interview stage, so it leads to a discrepancy in maybe the quality of their evidence. Why not front load it and have it at the earlier stages? And finally, broader intermediary involvement beyond the court. So at the minute we have a brilliant scheme, and I really want to stress that. We respect the rights of children better than most jurisdictions. But let's say, for example, victim or witness involvement beyond the court at sentencing hearings. I know our victims commissioner at the minute in Northern Ireland is very keen for victims to have transcripts of sentencing outcomes for victims. Some victims and witnesses may need assistance to understand exactly what a perpetrator got or what that means for them. Or, for example, at youth conferencing in our youth justice system, young witnesses and victims are involved in that. We don't have intermediary assistance at that stage for either young offenders or young witnesses. that's a space that definitely could be expanded into. If we had a magic money tree, perhaps we could have 3 or 4 times the amount. I suspect it does come down to funding as well, but I can at least try to give you some steps going forward. That's about 10 seconds over, so I'll leave it there. Thank you.